Good day, everyone. We are Group 3, and today we will be talking about a very important law that helps protect our personal information, the Republic Act number 10173, also known as the Data Privacy Act of 2012. My name is Sarah Marie Vidas, and I will be introducing our topic for today. This law was passed in the Philippines to protect the privacy of individuals and to make sure that our personal data is handled properly, whether it's collected, stored, shared, or used in any way. This law also gives us important rights, like the right to access our data, correct it, or even request its deletion. In short, the Data Privacy Act helps keep our personal information private, secure, and protected. So the Data Privacy Act of 2012 states that an act protecting individual personal information in information and communication systems in the government and the private sector, creating for this purpose a National Privacy Commission and for other purposes. Moving on to the Declaration of Policy. It is the policy of the state to value every person's right to privacy and communication, while also supporting the free flow of information to encourage innovation and development. It recognizes the importance of information and communications technology in building the nation and is responsible for ensuring that personal data in both government and private systems is safe and protected. Here are some terms you will come across in the Data Privacy Act. First is commission. This means the National Privacy Commission, the government agency in charge of making sure the law is followed. Consent of the data subject. This is when a person freely and clearly agrees to let someone collect and use their personal information. Consent can be written, recorded, or electronic. Data subject. The person whose data is being collected or processed. Direct marketing. Any advertising or promotional messages that are sent directly to specific people. Filing system, a structured way of organizing information about people so that specific details about someone can be easily found, even if it's not by a computer. Information and communication system, any system like a computer or online platform used to send, receive, store, or process electronic data or messages. Personal information, any information that can identify a person either by itself or when combined with other data. Personal Information Controller, a person or organization that decides how personal information is collected and used. This does not include someone who is just following instructions or using the info for personal or family matters. Personal Information Processor, someone who processes data on behalf of a controller, usually as part of a job or contract. Processing, doing anything with personal data, such as collecting, storing, changing, using, sharing, or deleting it. Privileged information, data that is protected by law, such as private conversations between a lawyer and a client or a doctor and a patient. Lastly, sensitive personal information, very private data, such as health, education, court cases, or criminal records. So, next, I will talk about the scope, or what the law applies to. This law covers all kinds of personal information being processed. It applies to any person or organization if they use equipment located in the Philippines or they have an office, branch, or agency in the Philippines. Moving on to the exemptions. This law does not apply to the following types of information. One, the government employee's job related info, such as their name, position, government office, their salary range, their work info, and documents that they made as part of their job. Second, people working under government contracts if the info is about the work they did or their name as part of that service. Number three, details about government benefits, like license or permits given to a person, the name of the person who received the benefit, what the benefit was, and number four, info used for journalism, art, literature, or research. Number five, personal data used by public authorities like law enforcement agencies. Number six, data needed by banks or financial institutions to comply with banking and financial regulations. And number seven, data collected in other countries that follows the privacy laws of those countries or is just being processed here in the Philippines.
Hi everyone, I will be reporting Chapter 3, which is Processing of Personal Information under Data Privacy Act 2012 or Republic Act 10170. First, let's talk about general principles of processing found in Section 11. The law states that personal information should always be processed lawfully and fairly, and it must serve a legitimate and declared purpose. The data should be accurate, relevant, and updated when necessary, and it must be kept secure and retained only for as long as needed. Next, in Section 12, the law explains when processing of personal information is lawful, this is allowed if the data subject deems consent, if it is necessary to fulfill a contract or to comply with a legal obligation, to protect vital interests of a person, or to pursue legitimate interests provided that the rights of data subject are not violated. For Section 13 and 14, which deal with sensitive personal information and privileged information, strict rules apply. These include data about health, genetics, sexual life, or political or religious affiliations. Processing is only allowed if there is explicit consent, if it is needed for medical treatment, law enforcement, and protection of lawful right, or if required by law. The law also regulates data sharing and outsourcing. Any sharing of data must follow the principle of transparency, legitimate purpose, and proportionality. Agreement must be placed to make sure that personal data is protected. Lastly, there must be safeguard in processing. This means ensuring confidentiality, integrity, and security of personal information and preventing unauthorized access. Hi everyone, I will also discuss Chapter 4 of Data Privacy Act of 2012, also known as Republic Act 10173. This chapter focuses on the right of the data subject because in nursing informatics, the data subject usually refers to our patient whose personal and health information we handle. Protecting their privacy is not just a legal duty but also an ethical responsibility as future nurses. So number one is the right to be informed. This means that the patient must be told when and why their personal or medical data is being collected. They should know how it will be used, stored, and who will have access to it. Number 2 is the right to object. Patients have the right to refuse processing of their data if it is not directly connected to their care. This includes activities like marketing, profiling, or research without consent. Number 3 was the right to access. Patients are entitled to request and obtain a copy of their medical record and also to know who has access to their information. And number 4 was right to rectification. This means patient can request correction of inaccurate or incomplete health information. And also number 5 is the right to erasure or blocking. So patient can demand the deletion or blocking of information that is no longer necessary or unlawfully obtained. And number 6 was the right to damage. If patient privacy rights are violated, they have the right to claim compensation. And lastly, the right of the data portability. So patients have the right to transfer their health record from one healthcare provider to another. So, the right of the data subject empowers patients to control their personal health information because in nursing informatics, it is our responsibility to uphold rights by ensuring confidentiality, accuracy, and ethical use of health data. By respecting their rights, we protect our patient privacy and strengthen their trust in healthcare system.
I am Annalisa Yanez and I'll be presenting Chapter 5 Security of Personal Information. So, this outlines the responsibilities of personal information controllers in safeguarding data. This chapter is a cornerstone of privacy protection, emphasizing the need for comprehensive security measures to prevent unauthorized access, destruction, alteration, or disclosure of personal data. At the heart of this chapter, it is a clear mandate that personal information controllers must implement robust, multi layered security systems to protect personal data. These systems must be designed to address both natural disasters and human threats, such as unauthorized access, fraud, or data breach. So, first is a multi layered protection. So, security must be implemented across three dimensions, which are first organizational. So, this is where it focuses on policies, training, and access control. Next is physical, which focuses on securing facilities, equipment, and physical records. And lastly, technical. This is where firewalls, encryption, and security systems are. So the level of protection must match the sensitivity of the data, the risk involved, and the size of the organization. Second, controllers must protect networks from unauthorized use or interference, establish formal security policies for data processing, conduct vulnerability assessments and prepare incident response plans, monitor systems regularly, and prevent breaches proactively. Third is third party compliance. Any third party processing data on behalf of the controller must follow equivalent security standards. This ensures that data remains protected even when outsourced. Fourth is confidentiality requirements. All employees and agents must uphold strict confidentiality. Importantly, this obligation continues even after employment ends, reinforcing long term accountability. Lastly, breach notification. In case of data breach involving sensitive personal information, the controller must promptly notify both the Commission and the affected individuals. The notification must include the nature of the breach, the type of data involved, and the measures taken in response. Finally, all security measures must be proportional. This means the more sensitive the data, the stronger the protection. Measures should also consider the complexity of operations and the cost of implementation. Best practices in privacy and data protection must guide these decisions. Chapter 6 Accountability for Transfer of Personal Information, which highlights the continuing responsibility of personal information controllers, or PICS. When personal data is transferred to third parties, so even when personal data is handed over to another organization or processor, the original controller remains fully responsible for how the data is handled. This accountability applies whether the transfer occurs within the country or across borders. PICS must ensure that personal data remains protected regardless of where it is processed. This includes transfers to local third party processors or international transfers, when which require compliance with cross border arrangements and cooperation requirements under the Data Privacy Act. So, when data crosses national boundaries, PICS must also evaluate the receiving country's data protection standards, use legal instruments such as contracts or binding corporate rules, and cooperate with regulatory bodies to ensure lawful and secure processing. So, this chapter has a vital principle, which is accountability cannot be outsourced. So, when data is transferred or processed by external entities, the original controller remains fully responsible for its protection. So, we have Section 21A or also known as the comparable protection. So the first obligation is ensuring comparable protection. So when personal data is transferred to third-party processors, PICS must guarantee that the same level of security and privacy is maintained. This can be achieved through contractual agreements such as data sharing or processing contracts, or other reasonable means like audits or compliance certification. Importantly, PICS must continue to comply with all provisions of the Data Privacy Act, regardless of who is handling the data. Next is Section 21B, or also known as designated accountability. PICS are required to designate specific individuals who will be responsible for ensuring compliance with data protection law. These individuals serve as the point person for privacy related matters and are held accountable for the organization's data protection practices and must be identified and disclosed to data subjects upon request. So these sections make it clear that organizations cannot transfer away their legal and ethical responsibilities. Even when outsourcing data processing, the PIC remains fully accountable for how personal information is handled. So we have Chapter 7, Security of Sensitive Personal Information in Government, which outlines the legal and operational safeguards required when government agencies handle sensitive personal data. This chapter establishes a robust security framework built on standardized measures, controlled access, and strict accountability. The primary goal of this chapter is to ensure that sensitive personal information held by government agencies is protected through comprehensive and industry standard security protocols. These requirements apply not only to internal operations but also to third party contractors and external data access. So, under this chapter, we have Section 22 Agency Responsibility. Government agencies are required to implement industry standard security measures to protect sensitive data, ensure that agency heads are directly accountable for compliance, and cooperate with the Commission, which monitors and enforces these standards. This section reinforces leadership accountability and institutional responsibility. Next is Section 23 Personal Access Controls. Access to sensitive personal information is strictly regulated for on site or online access. Personal, personnel must obtain security clearance from the agency head. For off site access, additional controls are applied, which are approval that must be granted within 2 days. Requests are limited to only 1,000 records. All data must be encrypted. And lastly, agencies have a 6 months timeline to fully implement these controls. So these measures ensure that access is both justified and secure, minimizing the risk of unauthorized disclosure. Lastly, we have Section 24, or contractor requirements. When government contracts involve the processing of data for 1,000 or more than 1,000 individuals, contractors must first register with the Commission and comply with the same security standards imposed on government agencies. So, this guarantees that external partners uphold the same level of protection, maintaining consistency across all data handlers. So, after all of this, Chapter 7 reinforces the government's duty to protect sensitive personal information through first, standardized security protocols, controlled access procedures, and strict accountability for both internal personnel and external contractors. These provisions help build build public trust and ensure that privacy rights are respected across all level of government operation.
Lastly, I will talk about miscellaneous provisions. These are non-specific but often essential terms and conditions that are not addressed in the primary sections of the document. These provisions are often overlooked. So first, Section 38 states interpretation. Any doubt in the interpretation of any provisions of this Act shall be liberally interpreted in a manner mindful of the rights and interests of the individual about whom personal information is processed. So, if there is confusion in the law, it should be interpreted in favor of protecting people's personal data and privacy rights. Next, Section 39, implementing rules and regulations. Within 90 days from the effectivity of this Act, the Commission shall promulgate the rules and regulations to effectively implement the provisions of this Act. This means within 90 days of the law becoming effective, the National Privacy Commission must issue clear guidelines on how to enforce the law. Section 40 Reports and Information. The Commission shall annually report to the President and Congress on its activities in carrying out the provisions of this Act. The Commission shall undertake whatever efforts it may determine to be necessary or appropriate to inform and educate the public of data privacy, data protection, and fair information rights and responsibilities. This means the Commission must report its yearly activities to the President and Congress and help educate the public about data privacy rights and responsibilities. Section 41 Appropriations Clause. The Commission shall be provided with an initial appropriation of 20 million pesos to be drawn from the national government. Appropriations for the succeeding years shall be included in the Government Appropriations Act. It shall likewise receive 10 million pesos per year for 5 years upon implementation of this act, drawn from the national government. This means the government will give an initial budget of 20 million pesos to the Commission plus 10 million annually for 5 years to support its operations. Section 42, Transitory Provision. Existing industries, businesses, and offices affected by the implementation of this act shall be given 1 year transitory period from the effectivity of the IRR or such other period as may be determined by the Commission to comply with the requirements of this Act. This means businesses and other entities have 1 year or more if extended from the release of the IRR to comply with the law. Section 43, Separability Clause. If any provision or part hereof is held invalid or unconstitutional, the remainder of the law or the provision otherwise affected shall remain valid and subsisting. If one part of the law is declared invalid or unconstitutional, the rest of the law still stands and remains in effect. Section 44, Repealing Clause. The provision of Section 7 of Republic Act Number 9372, aka the Human Security Act of 2007, is hereby amended. Except as otherwise expressly provided in this Act, all other laws, decrees, executive orders, proclamations, and administrative regulations or parts thereof inconsistent herewith are hereby repealed or modified accordingly. Repealing clause is that any previous laws or regulation that conflict with this act are changed or repealed to align with the Data Privacy Act. Lastly, Section 45, Effectivity Clause. This act shall take effect within 15 days after its publication in at least two national newspapers of general circulation. So, obviously, that this means that law officially takes effect 15 days after being published in two national newspapers. So, that concludes our report on the Republic Act 10173 or the Data Privacy Act of 2012. Thank you.